Well, you know what I think? Enter something criminal or offensive or something that implicates you for liability. Send. Oh no, what did you do? Fast forward 3 years and you're in a trial. The opposing counsel is now trying to enter that text message as evidence against you. That's what we're talking about today. I'm Eric Ganchi, and this is Law on Edge, bringing you cutting-edge laws to keep you at your sharpest. Why did you hit send when you were angry? That text you fired off in the middle of the night, the one you hope that they'd just get over, can end up read into the record in front of a judge and or a jury deciding your future. And in one recent California case, a single text message, a threat to kill the mother and unborn child, became a key piece in an adoption battle that changed the child's entire legal future. Welcome to Law on Edge, a podcast presented by Antonian Miranda and hosted by me, Eric Ganchi. I'm a California trial lawyer, and each week I break down new case law and courtroom strategies that could impact your practice and your daily life. With that, let's dive into today's case. Today we're talking about something you use every day without even thinking about it, your text messages. We'll cover how texts can get admitted into evidence, why they can be more dangerous than live testimony, and how one message, in this case adoption of XD, helped flip the outcome of a high-stakes adoption case. As a trial lawyer, I always see written communications as if they're read into the record as evidence at a trial. How will the jury or judge hear this evidence? And how will they react to it? And how many a lawyer try to use your words against you, maybe for the truth, but also for an outside meaning, like to prove your state of mind? Let's dive in. Now, before I explain the law and the strategy implications, I'm going to set up the case where this came to light. It's a family law case cited as adoption of XD, 114 Calop 5th 812. So we're in an adoption case, and the father wants to adopt the child. The mother opposes. Then comes the turning point. The father sends a text message threatening to kill the mother and their unborn child. His sister saves the message, and at trial, the court has these facts. The phone number in the screenshot, and the father admits at his deposition and again at trial that it's his number. The contact name for the sender is Little Big Brother, and the father testifies to that. Yeah, my little sister calls me that. The content of the message lines up with other evidence and with his own statements. So during the trial, the court verifies on both sides that the phone number has been authenticated. Mother sought to introduce this text at trial, and the trial court excluded this evidence. The mother appealed, which brings us to this case. We'll start with first how texts come into evidence. Can text messages be used in trial as evidence? The answer is yes, absolutely yes, they can. As an attorney, I look at every written communication as if it might one day be read out loud in a packed courtroom, and if so, how will a judge hear it? How will a jury react to that? And how might a lawyer use your own words against you? Not just to prove your state of mind or your intent or your knowledge, but also to prove the truth of the message. So let's break down this process. Foundation. Foundation for a text or an email may be laid through direct or circumstantial evidence. The court here says this: like any other material fact, the authenticity of a document may be established by circumstantial evidence. And sometimes evidence of writings can be self-authenticating. Per California Evidence Code section 1421, a law states, a writing may be authenticated by evidence that the writing refers to or states matters that are unlikely to be known to anyone other than the person who is claimed by the proponent of the evidence to be the author of the writing. So does the person who wrote the text need to authenticate the text? No. Another person can authenticate the text, as the court here specifically says this: the author's testimony is not required to authenticate a document. You might say, isn't all this hearsay? Yes, but The court here held hearsay exceptions applied to this text message as being a state of mind made by a witness who is a party opponent. Also, the text message was offered for the effect it had on the mother's state of mind and her conduct regarding communication with the father about their unborn child. And that brings us to the father's one last fadeaway shot, his Hail Mary. He argued admitting the text message would be too prejudicial per California Evidence Code 352. And the court responds, not every damaging piece of evidence is prejudicial under Evidence Code 352. The law on prejudice is this. Prejudice, as contemplated by Evidence Code Section 352, is not so sweeping as to include any evidence the opponent finds inconvenient. Evidence is not prejudicial merely because it undermines the opponent's position or shores up that of the proponent. The ability to do so is what makes evidence relevant. The code speaks in terms of undue prejudice. So what exactly is prejudice? It applies to evidence which uniquely tends to evoke an emotional bias against the defendant as an individual and which has very little effect on the issues. In other words, evidence can be prejudicial, it just cannot be unduly prejudicial. The text message in this case was just one part of this appeal. The entire case also deals with the father trying to adopt his child against the mother's wishes and arguments. I don't do family law, but our firm has a team of fantastic family trial lawyers that do, so I will leave all the family law to them, and I'll focus my discussion on admitting evidence at trial as that applies to civil cases. In the end, for this case, the court reversed the trial court's findings that the father was the actual father and directed the trial court on remand to enter an order permitting an adoption to proceed. For trial lawyers, I have 4 strategy implications for you on your next case. 1, treat text messages as strategic weapons. So let me give you just one example of how you can use messages or text messages, social media messages as strategic weapons. There was a case that I was a part of where someone had posted on Instagram about how fast he was driving, and he was videoing himself while he was driving, and then there was some sort of a speed filter that was giving some estimation of speed while he was driving to show that he was going well over 100 miles an hour in the middle of the night. And then there was a message in addition to the post that said something to the effect of, I love driving so fast, I do this all the time, something like that. So that is all a created message, and all of that is hearsay, but the step-arounds for hearsay would be the exceptions for hearsay, so maybe to prove the state of mind of how that person is always acting, and are they always driving that fast, and also it could be used as a statement of a party opponent, and that something like that could also elevate a case where, in civil work that I do, if I'm just claiming negligence, but then if I have a post, or especially a series of posts of you driving and loving driving that fast and maybe doing it intentionally, then it may allow us on the plaintiff's side to be able to amend the complaint to allege punitive damages against you. So then it's not just getting damages to compensate the plaintiff to try to correct the injuries that you caused, but also to punish you for what you've done. 2, use circumstantial evidence to authenticate messages when the author won't cooperate. If you have a text message, and if you're the one that sent it, and then you're thinking, 3 years later and you're in trial and you're thinking, I hope that doesn't come in as evidence against me because it reads poorly or it proves like an element of the case, but we don't need you to authenticate it. If you sent it to somebody else and they grabbed it, they screenshotted it, and then if it's very clearly, like if we can establish that it came from your phone, that the person that you sent it to is like your family member or someone that would be able to stand up and testify against you, then all of that may be self-authenticating against you, and there's a chance that may come in against you at the trial, and that can be really, really damaging evidence. Something else to consider too is that once the evidence is so clear that it's going to come in, sometimes parties can stipulate to this evidence coming in. Even if you want your lawyer to fight it, sometimes it may be more appropriate, knowing that the evidence is going to come in anyway, just to simply stipulate to the evidence coming in, and that can also look really bad against you as well. 3, explore party opponent admissions and state of mind arguments to overcome hearsay. So if you write something and it's a text message that is a writing and it's out of court, assuming that you didn't text it inside court while you're on the stand. That's going to be considered hearsay because it's an out of court statement. And so then you would be able to say objection, hearsay, or your lawyer would say objection, hearsay. But if you're a party to the case and if you're the one that wrote it, then there are exceptions to hearsay. So one exception is if you're a party opponent, so you're a party in the case and you're opponent to the party that's trying to introduce the evidence. So that can be one way to admit the text message against you as a party opponent admission or party opponent statement. Another way to get around the hearsay exception is to prove your state of mind. So if you're saying something like texting somebody or posting something on social media about, I'm so glad that I did this, I'm so glad that I hurt this person, I hope that they're really hurt, I really don't like them. So all that stuff is hearsay, but do we need to prove that you really didn't like someone? Maybe, maybe not. But can we use a hearsay exception of your state of mind to prove what state of mind that you were in, either when you were writing the message or when you were doing whatever wrongful act it was against the plaintiff? So there's lots of exceptions for the hearsay rule, and it's just one of the many reasons why you may want to consider if you want to hit send on that button before you send a text message, because that may be something that there may be a workaround for a hearsay exception that can be used against you. 4. When facing a 352 objection, argue that the emotional impact comes directly from the evidence relevance and not from unfair bias. It's often a fadeaway shot, and something that lawyers always object to evidence code 352, saying, Judge, this is way too prejudicial, it's unduly prejudicial. But usually when that's happening, and especially if you're doing it in front of a jury, first of all, when you're objecting, all that does is alert the jurors that, hey, something important is happening and you're trying to keep it out. If it's prejudicial, the court can still let that in against you. If it's unduly prejudicial, then maybe not. So let's say that it was this comment that has nothing to do with the case and it really puts you in a bad light for reasons that are not connected with the case at all, then maybe that would be considered unduly prejudicial. Or maybe if it was like you had a felony conviction that was like 40 years ago for something that has nothing to do with the case, sure, maybe that's unduly prejudicial. But if it's something about the case and you just don't want it to come in because it's going to hurt you or hurt your case, that doesn't mean that it's unduly prejudicial. That just means that it's good evidence against you. So there is a big difference between is it prejudicial and unduly prejudicial. For everyone else with a phone, listen up. Anytime you type something, you are potentially writing future evidence. Angry threats, angry texts, drunk messages, ultimatums, all of this can be used. All of it can be screenshotted, used, saved, and then read into a court years later. If you wouldn't want a judge reading your message on a giant screen behind you, don't send it. In today's world, it can be so easy and so tempting to hide behind the anonymity of a screen. That is why it is so important when you're online to really examine if this is something that you would say to that person's face. And even more importantly, is it something that you would really stand behind in a courtroom in front of a judge and a jury? Here's the edge. In a modern trial, your phone is often Exhibit A. California courts routinely authenticate and admit text messages and emails, even without the sender's cooperation. One message can shift the balance on credibility, state of mind, fear, and parental fitness. Justice isn't just in what you say under oath, it's in what you sent at midnight when you thought no one else would ever see it. I'm Eric Ganchi. This is Law on Edge, the sharpest look at California's changing laws. Subscribe for more courtroom strategies, new cases, and insights that keep you on the cutting edge. And if you're facing a case where text messages or digital evidence might be used for or against you, reach out. Until next time, think before you hit send.